not the place to argue your case.
Judge, in this case, in this particular case, Judge,
not in this case.
Not that I'm aware of. This is the first I've ever had it happen, and I've been a judge for 12 years. At least it's the first time it's been reported to me, and my staff's pretty good.
Welcome back to Advocacy Alchemy with Professor Ross. Tonight we'll talk about an interesting subject. We're going to talk about perjury, which means to lie while under oath. I want to talk about why you should never lie to the judge. This video we're going to watch is from Texas. It's from Jefferson County, Texas, which is Beaumont, or somewhere thereabout. We're going to listen to a judge who is speaking to a defendant who is trying to take a plea. Let's find out what happens. This is interesting. As always, we're going to be searching for something. We're not searching for Texas law for booster seats, but let's see, Texas law for perjury. All right, that's found in the Texas Penal Code, section 37.02, perjury. In Texas, perjury is defined under Texas Penal Code, we just said. A person commits perjury if, with the intent to deceive and with knowledge of the statement's meaning. Number one, they make a false statement under oath or swear to the truth of a false statement previously made, and the statement is required or authorized by law to be made under oath. All right, number two, they make a false unsworn declaration under Chapter 132, Civil Practice and Remedies Code. All right, that's something very specific to what they have going on in Texas. All right, let's look at what is the punishment. Perjury is classified as a Class A misdemeanor in Texas, punishable by up to 1 year in county jail and a fine of up to $4,000. Let's look at the classifications of, not criminals, I guess, but let's do crimes. In Texas, felonies and misdemeanors. Okay, it says that misdemeanors are divided into three categories. You have Class A misdemeanors for the most serious misdemeanor. That's punishable by up to 1 year in jail, a fine of up to $4,000. All right, you have Class B. That's up to half a year in jail and a fine of half of the $4,000, which is $2,000. Class C misdemeanors. These are the least serious misdemeanor in Texas. All right, punishable by a fine not to exceed $500. Looks like it didn't even have any detention with it. All right, just a fine. So that's a ticket in most places, or wherever you may call your citation. On the felony side, remember, usually felonies simply mean that you could be in prison for more than 1 year. All right, I'm looking at some crazy numbers as I look back at my screen, the 5s to 99. But all right, so capital felony. Usually in most states, when they use the term capital along with something else behind it, means that you can probably receive the highest level of punishment in that jurisdiction. All right, in Texas, I believe they still have, yes, they still do have death on the table. All right, the most serious felony punishable by life imprisonment, without parole, or the death penalty. All right, let's talk about life imprisonment. All right, you can have with parole or without. If you're on life imprisonment without parole, that means there's no possibility that you will ever leave prison. All right. You may wonder, when do certain cases get the possibility without parole? All right. A lot of the convictions that happen in the teenage murders of other people, whether it be school shootings and things of that nature, they may have life imprisonment without parole. Okay, and that's due to the cruel and unusual punishment from the Constitution, basically. All right, so basically, the freedom to be free of any cruel and unusual punishment. That goes really to that you can't confine a person that's younger than the age of 18 to death. All right, but that's too much on that. Let's go to first-degree felony. That's punishable by 5 to 99 years in prison and a fine of up to $10,000. Second-degree felony, punishable by 2 to 20 years in prison, a fine of up to $10,000. Third-degree felony, punishable by 2 to 10 years in prison, a fine of up to $10,000. State jail felony. So they even have a fourth-degree sort of felony where you can just be confined to jail. So when you hear the terms jails versus state penitentiary, all right, the difference is the county usually runs the jail facility. Now there are people that can be in jail for a long period of time. Most of the time up to 1 year, but most of the time even longer than that, because in many locations, I can't speak for all, but in many locations, the state penitentiary does not have room for people, so they must remain as a ward of the state while in county jail. All right, so the state jail felony is punishable by 180 days up to 2 years in a state jail, a fine of up to $10,000. Okay, so let's jump in. We heard perjury was a class A, which gives you up to 1 year in jail and a fine of up to $4,000. With that information in mind, let's jump over to our video. And I'll have all credit in the description below to who brought this video. I believe their sign is going to come up in just a moment, so we'll see it. All credit to y'all. Thank you. And let's hear what's going on.
You're making a farce out of this whole. This is supposed to be all about truth. Andy here first. That's you. 24 CR. And you are here with Ms. Minaldi, your attorney, and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment? Can we proceed in summary?
Yes.
In summary, this indictment alleges that on or about June 6th.
Okay, so you heard him ask a question right there off the bat. All right, well, we know this is in Texas. We see the Texas flag, but he also said this is in the Jefferson County Court of Texas. All right. He asked at the very beginning if they wanted to waive basically the formal reading of the arraignment, which is the full reading of what the charge is with all the legal language. And sometimes it can take, 5 or 6 minutes to read through all the paperwork. So he's asking if they wish to waive the reading. He's asking the attorney. The attorney answered yes, so he's just going to, instead of going over all of it, he's going to give it in summary. All right, so let's listen what the summary is. We'll back up just a little bit. We're gonna let this bad boy ride. Let's see. All right, we'll go back right here, and we're letting it play.
A formal reading of the indictment and arraignment, can we proceed in summary?
Yes.
In summary, this indictment alleges that on or about June 6, 2023, in Jefferson County, Texas, you committed the state jail felony of theft. You understand what you're charged with?
Yes.
If convicted of a state jail felony, you face confinement in state jail for any term of not less than 180 days or more than 2 years. Additionally, you may be assessed a fine not to exceed $10,000. Do you understand?
Okay, so we heard him talk about state jail felonies. Remember, we just looked that up. He said carries a punishment up to 180 days in jail and a fine of up to $10,000. He said this felony is called theft. Let's look it up like this and see what it pulls back. In Texas, theft is considered a state jail felony when you value the property stolen is $2,500 or more, but less than $30,000, okay? This classification is punishable by a sentence ranging from 180 days to 2 years, all right? In a state jail and a fine of up to $10,000. All right. So you see, that's how we get this is just theft. They have a different level or different type of crime when you go beyond this number here. Or when you're below this number here. It's called something different. It's not state jail theft. Do you understand? All right, let's jump back in and let's see what Judge Stevens, that's who we're watching. Let's see what Judge Stevens has to say.
Yes.
Agreement's been reached. You would be pleading guilty, placed on deferred or unadjudicated probation. That can be up to 5 years in length. Restitution is owed in the amount of $3,408.18 to the complainant in this case. Just looking at something. Stand. Just.
Okay. Let me give some advice to everyone out there. This is common sense advice. If you're going to court and you have a judge do this move here, not the coughing, but look at the whole facial expression after he was looking at something. He said, "Give me a second here, I'm looking at something." Look at his face where we paused it right here. Boom, boom.
Judge, in this case, in this particular case, Judge.
Not in this county.
Not in this county. Let's see what's going to happen with Judge Stevens and lecture point. Perfect lecture point. Let's go.
There are different ways to handle matters, right? It has been over a year. June was a year ago. It's September, so it's 15 months that this money has been displaced. Take it that you're about to plead guilty to. Not one dime has been returned. Not one thin penny.
Okay, so you see what the issue is. When he looked at the paperwork, he was trying to see how much was paid back in restitution or pre-adjudication payments. Okay? Sometimes when a person has been caught after having stole something, they can give it back. If it's money that's been spent or hot checks, people can sometimes mitigate some of the punishment by saying they have paid the money back. That's why he's upset. Let's keep listening.
But after 15 months? Why?
I didn't even know that there was like they press charges or anything. I didn't.
Ma'am, you want me to read the probable cause affidavit out loud to everybody? You don't, because I've read it and it's not good for you. You were told about this back in June 6th. And you were in a position of trust. This was a fundraiser.
All right, so you hear that this is a fundraiser that she's taking money from. He said a key term: theft while in a position of trust. Let's make sure we got both of these pulled up so y'all can see. All right, in Texas, committing theft while in a position of trust, such as a fiduciary role, can lead to serious legal consequences, including both civil and criminal penalties. This just means a role of trust. This term is a legal term, but it can be for a number of different titles to a person who is deemed to be a fiduciary. I mean, they are watching over something for the benefit of another person. All right, that's kind of simply the basic way of thinking about that term. All right, civil penalties. Victims may pursue civil remedies for breach of fiduciary duty, which can result in the fiduciary being ordered to return the stolen property or funds, pay compensatory damages to make someone whole again. That's what this term means, to make someone whole again. So if that was the modifier for damages, to pay damages that make someone whole again. Oh, well, hey, they even defined it here, so I'm actually talking out of turn. All right, to cover attorney's fees and court costs. In some cases, punitive damages. Punitive means punishment. May also be awarded to punish the wrongdoer and deter similar conduct. All right, engaging in theft or embezzlement while in a position of trust can result in criminal charges ranging from misdemeanors to felonies, depending on severity. Embezzlement. This involves the misappropriation of funds or property entrusted to an individual in a fiduciary capacity. Embezzlement may be charged as a felony with penalties including imprisonment and fines. Theft. As previously discussed, theft is classified based on the value of the property stolen. All right. When committed by someone in a position of trust, the offense may be considered more egregious, potentially leading to enhanced penalties. Tell me about the enhancements. In Texas, certain factors can enhance the severity of a theft offense, leading to more stringent penalties. These enhancements include use of a deadly weapon, targeting vulnerable victims, old people and children, elders and minors are always going to fall in this term type category. And almost every state in the United States recognizes that elders and minors and disabled people too, yes, are considered a vulnerable class of people. All right, so in offenses involving victims who are elderly or disabled may result in enhanced charges and penalties due to the increased vulnerability of these individuals. Theft of certain property types. Stealing specific items such as firearms, controlled substances, or high-value assets can lead to automatic felony charges, regardless of the property's value. Interesting. prior convictions. Anytime you're talking about most convictions and felonies and bringing certain charges, most states have a repeat offender type of statute. All right, so they will look back to see whatever type of felonies a person has. And if a person is always committing the same type of crimes or just crimes in general, they could face steeper penalties. All right, let's jump back in.
Or a teen. No, don't even, there's no dancing around on the issue, man. This is terrible. I mean, why didn't you, if you'd have paid it back, this probably would have been handled differently. But I mean, we're talking about softball, kids being hurt. What'd you do with the money?
All right, so you see that they have found on the internet, probably on Facebook, this actual charity event that she used to get the Cash App, and PayPal, and they even have a calendar there about donating, and she took all the money. All right, so let's keep watching.
What did you do with the money?
I didn't take the money. I have receipts and everything. I could have gone to trial, but I didn't want to because I need to.
No, we're going to go to trial.
Anytime that a person does this type of move with I could have or should have or anything like that, when it seems like it's a fairly agreeable plea bargain, if you upset the judge, he might not accept the plea as being freely and voluntarily entered into. If a person feels like they could do better going to trial, then you're probably going to go to trial. All right. Now, understand that there's always the situation where pleas and when they're accepted, that kind of determines whether the plea can be rescinded or anything of that nature. Right now, they're in the phase where the judge is he's going to hear out the charges, he's going to hear from the person themselves, and the person themselves must do a thing called allocution. Here, let's take a look at this term. I'm going to split the screen out. Let's take a look at this term, allocution. How do you spell this term? Allocution. In Texas. The term simply means when you must speak the facts, when the person themselves must stand accountable for what was done. Allocution in Texas. Let's see if we can. All right, allocution. I spelled it all the way wrong. I'm thinking I had a Q in there. It's LLOCUTION. All right, in Texas, allocution refers to the formal statement of a defendant. It's permitted to be to make before sentencing, offering reasons why the sentence should not be imposed or should be mitigated. All right. This right is codified under Article 42.07 of the Texas Code of Criminal Procedure, which states that before pronouncing sentence, the court shall ask the defendant whether they have anything to say why the sentence should not be imposed. All right, so if you're ever in court in Texas, they're probably going to even make this very exact statement. All right, but understand the laws are different in every state. So some states may not require allocution. All right. According to Texas law, or additionally, Texas law allows victims or their close relatives to present a statement to the court about the impact of the offense on their lives. According to Article 42.03b of the Texas Code of Criminal Procedure, the court shall permit a victim, close relative of a deceased victim, or a guardian of a victim to appear in person to present to the court and to the defendant a statement of the person's views about the offense, the defendant, and the effect of the offense on the victim. These provisions are aimed to ensure that both defendants and victims have the opportunity to be heard during the sentencing phase of a criminal trial. Okay. All right, let's jump back in.
So we'll do. You're not guilty. Don't look at me and say I didn't take any money.
Sure, but I can't risk I have a nursing license. I can't risk my children.
Well, you can't look at me and say I didn't take any money, but I'm going to plead guilty on this. I won't accept it. You're making a farce out of this whole. This is supposed to be all about truth. This is nothing about the truth.
Perfect time for.
I want the truth. You can't handle the truth.
Judge Stevens makes a perfect point. The process of accepting a plea is, you heard the term before, a come to Jesus talk. This is an opportunity for everyone to place out here on the table exactly what happened, for there to be a record to be made of this controversy being settled. And there's still controversy when you're talking about a criminal case, because there's a controversy between the state and a person who's being brought to trial, the defendant. So the whole idea of him accepting a plea, him being Judge Stevens accepting a plea, is that he's expecting this defendant to tell the truth.
No, you don't look at me and say, well, I'm going to plead guilty, but I'm not guilty. You would have to be, in fact, let me read to you what you've signed, okay? Let me read to you. I'm going to ask you to handle. Look at that first paragraph. That first paragraph. Did you sign that? Yes?
Yes,
Speak
sir.
out, please.
Yes, sir.
Read the last sentence out loud. Just out loudly.
I swear that well as I give is the truth, so help me God.
The sentence before that. No, on the first paragraph, the last sentence. What's the last sentence say in the first paragraph, ma'am? That's the top paragraph, the last sentence of the top paragraph.
This before the last one. I am guilty of the offense.
What'd you say?
I am guilty of the offense.
All right, so you see he's making her admit on the record and read out exactly what the statement says. I mean, the form says that you're admitting guilt to whatever offense. He's about to go in.
And then at the end, you swear under oath. Did you just commit perjury?
I mean, I'll take. I take.
That's not what you said a minute ago.
I take blame on some parts.
It's not unusual to get frustrated up here because people, the game is being played, and there's no game to be played up here. It's the truth.
Listen to him. He's cooking.
Judge, in this case, in this particular case, Judge, not in this county.
Judge Stevens, he's definitely saying, not in this county. You're not going to be able to do that over here. We're not playing any games, and this is serious time. It's serious, guys. When you or anyone you know has to show up in court, the time for games is over. All seriousness is there. I'll show you a clip that I have. But basically, it's when you go to court, if you've never been in court on a criminal day, now people have been to court for all types of different stuff, and you may have went to traffic court and had to wait all day just to hear about your speeding ticket over 10 miles. It's different when you go to felony court and you have sets of people that have to get brought in chains and shackles, shuffling. All right. And you hear about people getting very high bonds. All right. And it seems like things are going at light speed. You come into a room at the beginning of the morning and it's a room full of a couple hundred people in there. And there's decisions being made about many cases very quickly. As Judge Stephen said, people come in trying to play a game. Now is not the time for games. Let's jump back in.
Search for the truth. You either are guilty or not guilty. If you're not guilty, but don't say I'm pleading guilty, but I'm not guilty. When you swear under oath, you're guilty. And I'd ask the DA's office to please look into perjury charges. Good luck with that on your record.
That's the one thing about when you're in court and you get to these long pauses. If you're one of the people on this side of the table, either the attorney representing somebody or the defendant, everything goes to your mind because you don't know what this person is thinking right now and what they may do. Let's jump back in.
You were in charge of a fundraiser. You were responsible for $3,408 that was raised for the softball team. You did not immediately return the money to the league. When they reached out to you, you turned in a check for $3,408.18 from your deceased father's checking account. Tell me what's wrong about this, because this.
Okay, do you hear how it's getting worse? $3,408. Let's jump back over here. Let's go back up because we already seen the amounts for theft. Anything between $2,500 and $30,000. Found it. Make it big. All right, theft is considered a state jail felony with the value of property when the value of property stolen is $2,500 or more, but less than $30,000. Half a year in jail and up to 2 years in state jail. A fine of up to $10,000. Remember, while in a position in penalties. All right. Let's jump back in. Second thing, all right, remember he said that you wrote a bad check off of your dead father's account. Forgery. All right, this is found under the Texas Penal Code, section 32.21. A person commits forgery if and with the intent to defraud or harm another. They alter, make, complete, execute, or authenticate any writing so that it purports to be the act of another who did not authorize that act to have been executed at that time, place, other than was in fact the case. All right, so the key thing here, remember, her father is no longer here, so he cannot authorize any check made on an account, if the account even exists. All right, a person is trying to purport the act of another who did not authorize the act, or to be a copy of an original with when no such original existed. To issue, transfer, register the transfer of, pass, publish, or otherwise utter a writing that is forged. To possess a writing that is forged with the intent to utter it in a manner specified above. All right, basically trying to pass off what you know to be fake. Let's look at what the punishments are for forgery in Texas. You have a Class A misdemeanor. That's up to 1 year in jail and a $4,000 fine. You have a state jail felony. All right. If the forged writing is a will, deed, mortgage, security instrument, credit card, check, or similar commercial instrument, the offense is a state jail felony, carrying a sentence of 180 days to 2 years in state jail and a fine of up to $10,000. All right, so we know she has possibly 2 different felonies she's looking at, but she's only going to serve, or she's pleading to serve only under one of those felonies. All right, you have third-degree felony if the writing is part of a issue of money, securities, postage, or revenue stamps, a government record, or other instrument issued by a state or national government. The offense is a third-degree felony punishable by 2 to 10 years in prison, a fine of up to $10,000. All right, that's interesting. All right, so let's jump back in, hear what Judge Stevens has to say.
It's under oath, and I want to know who's not telling me the truth. You're shaking your head. Is that right or wrong? No, don't shake your head. It's because everybody's under oath here, and I'm going to start taking some scalps if we're playing games and the oath is being used irresponsibly. All right. The check was turned into softball league. They deposited it at Nature's Federal Credit Union in Beaumont. You were contacted and a few days later advised that the check had bounced for insufficient funds. Are we right so far?
Was never contacted. Because
This would be the police, I think, or somebody, or the bank, or somebody. Nobody contacted you at all. Is that what you're saying?
Well,
Under oath? Because you're under oath right now. Nobody contacted you about it.
Contacted me, yes.
All right, I want you to recognize something. Why he's asking her and he's telling her you're under oath is because the whole proceeding is also being transcribed and recorded. All right? Everything that you do in court is transcribed and recorded. He's already noted that he wants the district attorney there to look into perjury charges against her. That means they'll come and look at this whole proceeding and they'll pick out each one of the lies. If they're really gunning to get her, they'll basically just do a different perjury charge for each separate lie. She says that she's trying to get this matter dealt with so it doesn't affect her nursing license. I don't know. You see her attorney is letting the cards fall where they may. There's nothing the attorney really can do to save her right now. We'll see. But really, it's not much an attorney can do at this point. You can't tell your client to, all right, don't say anything. Give them the no sign. Because the judge is really on this point here.
Not that
The judge is about to be on one. And the defendant, all she can do is, all right, let's watch it.
Later, at a later date.
Pull this thing out of.
I'm sorry. I'm really new to this. Yes, sir, at a later date, not right when it happened. The detective would need to contact me.
The officer later confronted you about the whole situation, and you stated you did not write a check to the league with your father's checkbook. You came up with multiple possibilities about how this could have happened. None of them were reasonable or likely, they say. The check that's in your father's name was provided to the league is for exactly $3,408.18. What a coincidence. It would be not associated with the fundraiser. Also, it is not likely anyone else would have had access to your deceased father's checkbook. I later contacted you multiple times to come in for a statement and questioning, always had an excuse why you couldn't come in. You did send an email of screenshots of a group message with parents on the team in regards to the money, but none of it has any evidentiary value on it. You included a screenshot of an online bank statement for an unknown bank that showed a check was cashed from your account for the amount of $3,408, which is not the exact amount. The screenshot does not show the bank or the credit union.
Okay, so once again, all shout outs to the court nerds. You see here that Judge Stevens is now reading through the probable cause information. All right, it's all being read into the record. And what happens is, all right, when she takes this matter to trial, the state is simply going to bring back up the information. This hearing is public information. Let's see what happens. It's not much left.
Account holder name or number, nor does it provide any information that proves this is your account and that the check was cashed by the Nederland softball league. It was suspicious you told Officer Arsenault that you did not write the league a check, but that the money was given back to them. However, when I spoke with the defendant, she said you did write the league a check and the amount they claimed you owed them, and that was when you sent a screenshot, quote, was claiming to be the check withdrawn from your account. You have denied writing a check when speaking with the officer, but admit to writing one when speaking to me, and even sending a screenshot of what you claim to be proof of payment. Also, this check that was written to the league was for $3,408.18, and the screenshot shows a check was cashed from your account for $3,408.08, which is conflicting. $3,408.08, 10 cents difference is the difference. Conflicting amounts, again, proving you are fabricating evidence either through the screenshot of an account that could be anybody's or through your lies and deceitfulness. Well, they just added two and two together
Yeah.
kind of thing and came up with the math. It didn't work right. But what we're dealing with here is not manipulation with me. I'm not going to be a part of it.
Okay. I think we all can tell which way Judge Stevens is leaning. He's not going to accept the plea. It's obvious. He's going to make her go to a jury trial. And we'll see what the jury has to say once they hear the evidence. And the jury, remember, it's 12 people, members of the public, your peers. They're going to hear about how you've done something wrong. And they're going to stand in judgment. They're going to listen to all the facts. They're going to accept what the law is from the judge, and they're going to go back in the back and apply with the facts they heard and all that presentation from both sides, and they're going to make a decision. Let's jump back in.
I'm not going to watch it happen in front of me. And all of this is above. Came up with the math. It didn't work right. But what we're dealing with here is not manipulation with me. I'm not going to be a part of it. I'm not going to watch it happen in front of me. And all of this is above board, or else the whole respect and honor of this that we do goes down the toilet. And it's not going to do it on my watch. And I'm going to hold people honest and responsible for dishonesty up in front of me. You're charged with the crime of dishonesty, but right here, it didn't take you long for you to get on my bad side, because I don't put up with it. And say that the worst thing anybody can say out loud is, I'm pleading guilty, but I'm not guilty. I just did sign it. I am committing perjury, though, and I'm very happy to be doing that. But I want everybody to be to understand, well, that's not the way we do it. Everything is going to have to be fit in place and have to be answerable to the truth, or else we'll let a jury over there, a group of people who I'm sure would be fair. But I know when children are involved, being used.
All right, he's about to get into it. He's about to cook. All right, he's going to talk about from his own experience. All right, of being the judge, presiding over cases, and watching different juries and what they do in certain situations. If I had to bet on who, I bet on what he has to say versus anybody else in that jurisdiction. He knows the people. Let's hear what he has to say.
I know what juries do since I've tried 600 jury trials. Okay. I know what they do. They get angry. And they should be. Anyway, it's not going to be manipulated in front of me. So that's a long way of walking it back to this. I don't like this. I think a jury ought to decide, and then we'll see how that plays out. But you asked for it. You came up here
Can I
and
ask-
right out of your mouth, you were lying.
Can I explain, sir, what else means?
You thought about an explanation that
The, like the screenshots that,
I'm not talking about this. That's in that. I don't have the police officers here. I'm just reading to you what is said. But in the probable cause affidavit, they talk about you manipulating and not being deceitful. I'm talking about this. I'm going to plead guilty, but I'm not guilty.
I don't,
That's your problem with me. And I don't accept deals when you say, I'm under oath here and I am guilty of the offense and no lesser included offense. I swear all of this, as well as the testimony I give, is the truth. So help me God. You came right out of the box. And I know it's not the truth.
Shout outs to Judge Stevens and I think that's the Wacom Cintiq tablet. Nice. I see you out there shining. All right, jump back in.
Because you said it wasn't.
I don't,
You can't play it both ways. You gotta, maybe you have an issue, about honesty, but you're failing right now. We can't play, we'll play like you didn't say it. It's on the record.
it was just that there was two other ladies involved, and that's why I said, yes, I am guilty. Yes. I'm not the.
Perfect point here. What happens when you are one of many people involved in some kind of crime? Let's talk about this term here: joint and several liability. Joint and severable. That's what it should have been. All right, in Texas, joint and it should have been severable, which means to jointly and separately. So it's not the term several. It's simply just feed me back my term, but it's severable with a B in there. To sever. To cut. Is a legal doctrine that can apply in civil cases, particularly in tort law. Under this doctrine, when two or more parties are found to be jointly and severally liable for a plaintiff's injuries, each party is independently responsible for the full extent of the damages. All right. All right. Multiple defendants are held collectively responsible for the entirety of the victim's damages, even if each defendant individual contribution to the harm was minimal. This principle ensures the victims can seek full restitution from any one of the defendants, facilitating complete compensation for the losses. All right, they have specific statutes on this according to the Civil Practice and Remedies Code. Yeah, so it's talking about some civil liability. All right, let's jump back in. Let's listen to what the judge has to say in the very last of this.
That's what the screenshots was. Okay. I wasn't the only one that handled funds. If
I'm gonna reset this 4 weeks. We'll let state look into this. Y'all get to the bottom of this and we'll come back and see where we are. Okay, in 4 weeks. Thank you. Okay, is that it for you, Reagan?
Zachary Broussard is involved.
We also have Kevin Smith.
Okay, so once again, shout out to the court nerds. Great video to see why you shouldn't lie to a judge. Let's talk common sense for a quick moment, okay? When you think about one person having your fate in their hands, or one person being the decision maker for what's going to happen or what type of punishment you receive, you or anyone who's dealing with some issues, why would you tell a lie if they've already asked you to be upfront? It's never going to be a good thing.
I want the truth! You can't handle the truth!
And it seems like that, right? That someone may think that the judge can't handle the truth, but hey, it's better to tell the truth, especially when we're here on allocution of a charge during a plea. A truthful statement about what happened and that you're guilty of what happened. If that can't be had, then there's still the opportunity for a jury trial. Okay, with that, this was Advocacy Alchemy with Professor Ross. Hope you all enjoyed the lecture. Go and give the court nerds a view on this same video. The credits will be posted down in the description. If there's anything you'd like me to talk about, make a comment or send me an email. With that, this is Advocacy Alchemy with Professor Ross. You have a good evening. The street is not the place to argue your case.
Judge, in this case, in this particular case, Judge.
Not in this county.
Not that I'm aware of. This is the first I've ever had it happen, and I've been a judge for 12 years. At least it's the first time it's been reported to me, and my staff's pretty good.